Good morning and welcome everyone to the Massey City Summit. The topic of today's session is evolution of the legal and political treatment of cities. My name is Senator Ratna Omidvar, joining you from Toronto, although under normal circumstances, I would be speaking to you from Ottawa. I join you from the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and which is now home to many Indigenous peoples, including the Inuit and the Métis people. This session explores questions such as, what makes a geographical grouping a city? How did the evolution of the relationship among cities, provinces, and First Nations evolve? How have various tensions been resolved, addressed, or even exacerbated since Confederation, both legally and politically? We have a wonderful panel of speakers for today's session. They are Professor Kristin Good, Associate Professor, Department of Political Science, Dalhousie University. She is joining us from Halifax, Nova Scotia. Mariana Valverde, Professor of Criminology, University of Toronto, joining from Toronto. Patricia Wood, Professor, Graduate Program Director, Geography, York University, also joining us from Toronto. A few housekeeping issues before we begin. We would really like to know who you are, so please introduce yourself and so that we can hear where you are joining from, and please do so in the chat. This session will last for 75 minutes. Each panelist will speak for about 10 to 15 minutes. I will then ask the panelists a question and then invite you, the audience, to ask questions as well. Please add your questions to the chat, or you may raise your hands following the presentations, and we'll do our best to get you into the conversation. We encourage and welcome dialogue on the important themes raised by the speakers. With that, let's begin with Professor Kristin Good's remarks. Thank you.
Sorry, I think I was muted there. Okay. I would like to begin by acknowledging that Dalhousie University is located in Mi'kma'ki, the ancestral and unceded territory of the Mi'kmaq. I would also like to thank the conference organizers for inviting me to participate on this panel, and just to say how much I've enjoyed the panels yesterday and the panel this morning, and I'm looking forward to both today and the panels tomorrow. It's been an absolutely fantastic conference to date. In my remarks today, I will summarize 3 ideas that I developed in a paper entitled Moving Beyond the Creatures of the Provinces Doctrine, Exploring Pathways to Municipal Empowerment in Provincial Constitutions. First, I argue that municipalities ought to be thought of as part of provincial constitutions, and not only as creatures of the provinces in the sense that the doctrine is generally conceived. Second, I argue that it is possible to entrench municipalities in provincial constitutions in limited ways through the use of manner and form limitations. And third, I consider 2 pathways to municipal recognition in provincial constitutions, including in a comprehensive and consolidated provincial constitution on the one hand, and through incremental evolution of provincial constitutional orders on the other hand. I will elaborate briefly on each of these points. First, following David Cameron's pioneering work, I offer a novel interpretation of municipalities' place in the current constitutional order, arguing that establishing and altering municipal institutions should be considered a form of constitutional politics at the provincial level. A lot of emphasis is put on the fact that in the Canadian Constitution, municipalities are a legislative responsibility of provinces and not recognized as an independent order of government. They are so-called creatures of the provinces because they are created by provincial legislation instead of entrenched as a separate order of government in the Constitution. then a step is taken to view them as a legislative power like all others. According to this logic, creating municipalities is no different than passing a law on health, education, or transportation policy. I argue that we have to abandon the legal and political fiction that creating systems of democratically elected municipalities and or amending long-standing municipal institutions is equivalent to enacting laws in areas of in other areas of provincial jurisdictional authority. Rather, I argue that we should see municipal institutions as part of provincial constitutions, an element of Canada's constitutional tradition that has not received very much discussion and needs much more attention if democracy is to thrive in Canada. Legislation enacted under the authority of Section 92(8) is a constitutional act. Municipal acts and city charters divide power and responsibilities between two orders of government and establish democratically elected councils as governing bodies. They serve constitutional functions at the provincial level and should be recognized as such. In fact, authority to legislate in the other areas listed in Section 92 and other sections establishing provincial powers, as well as powers recognized as provincial responsibilities in court decisions, could all be delegated to municipalities, highlighting how provincial responsibilities for municipal institutions is inherently different. Conceptualizing municipalities and municipal systems as elements of provincial constitutions involves embracing the British tradition of constitutionalism, which is flexible rather than limited or flexible type of constitutionalism that includes laws of constitutional significance called organic laws to distinguish them from ordinary legislation. Fundamentally, we need to shift our political culture and thinking about municipalities and their purpose in our constitutional system. But still, even if one accepts that municipalities and municipal systems are constitutional in nature, this leaves us with the thorny issue of the difficulty of enacting limitations in flexible constitutions such as provincial constitutions. Recent provincial unilateral decisions to impose reform on the City of Toronto provide clear evidence that limitations on provincial authority are needed to protect local democracy in Canada, which brings me to the second idea in my paper. The second major idea that I discuss in the paper provides a practical solution to this problem. I propose that manner and form limitations could serve as a form of entrenchment of municipal authority in provincial constitutions by placing procedural limits on provinces' power to change municipal acts and city charters to reflect the fact that such laws serve constitutional purposes. The dominant thinking in the past has been that the principle of parliamentary supremacy or sovereignty, so crucial to our parliamentary democracy, means that a parliament, or in this case, a provincial parliament, in the present cannot pass laws that bind a future provincial parliament. Furthermore, provinces have the power to change their own constitutions, which many experts consider to mean that constitutional changes follow the same legislative process of a majority vote. This means that a city charter passed into legislation in one parliament could be amended by the next parliament by a simple majority vote, just like any ordinary law could be. However, some constitutional scholars now hold a more nuanced idea of parliamentary supremacy. These scholars make a distinction between the substance of laws and the process by which they are passed. According to this new version of parliamentary supremacy, a parliament can indeed bind a future one to a more difficult process to amend a law in the future, but cannot bind it to the law's substance. For instance, a provincial parliament could not bind a future one to a particular policy about the size of a municipal council, municipal boundaries, or a municipality's areas of authority, but it could establish a more difficult process that a future provincial parliament would have to follow in order to amend the law. These self-imposed procedural constraints on a parliament's ability to amend laws are called manner and form limitations. Examples include a requirement of a supermajority vote, say a 2/3 majority vote in the legislature to change a law, a referendum, or even a legally binding need for consultation with the municipality before a change to a provincial law could be enacted. Although there is some debate about their effectiveness and whether they would be upheld by the courts, some of Canada's top legal scholars and political scientists argued that they would be upheld were they designed in a particular way. The beauty of these legal mechanisms is that they're flexible and could be adapted to different laws that govern municipalities and city charters, or even specific parts of these laws. In my opinion, they should be developed in a way that ensures that provinces still have the flexibility to pass laws in the interest of a metropolitan area or even the province as a whole. If their legislative objectives are sufficiently important to warrant limiting the principle of local democracy by imposing an unwanted change upon a municipality. In fact, it is likely that manner and form mechanisms that couldn't be overridden by provinces would not be upheld by the court. In my view, the flexibility of the current system is a virtue that should be maintained. We need to be able to adapt municipal laws and city charters to the changing needs of metropolitan areas and provinces. For instance, Toronto City Charter could contain a requirement of the city's consent to change it, that the province could override with a 2/3 majority vote in the provincial legislature if it felt that its legislative objectives were sufficiently important. Manner and form limitations are essentially a limited form of entrenchment, of constitutional entrenchment, which brings me to my final point. In my paper, I outline 2 ways that municipalities' constitutional importance could be recognized and protected in provincial constitutions. First, as an overall process of codifying a comprehensive constitution, which is the way a lot of people understand constitutions in Canada, and in a more incremental way that is tailored to the municipal sector. In my opinion, there are virtues associated with both options. However, for reasons of flexibility and feasibility, in the paper, I argue that the best way to proceed, at least on the short term, is with organic and tailored constitutional change by enacting manner and form limitations in municipal acts and city charters. This position also builds on constitutional change, albeit constitutional change that has not always been recognized as such by many, that has already occurred in municipal acts and city charters that have been reformed in many provinces since the mid-1990s. Professors Robitaille and Freit gave a really interesting presentation on one example of what I would call this organic constitutional change that has been taking place in provinces across Canada since the mid-1990s. It reflects a British tradition of constitutionalism and constitutional evolution that is organic. In fact, there is also at least one example of a municipal act that contains clear manner and form limitations, BC's Community Charter, passed in 2003. Its commitment to consult municipalities on a variety of changes is stated as a procedural requirement for particular types of changes to municipal legislation, and its ability to impose amalgamations is limited by a requirement of a referendum and a 50% vote in support of amalgamation in each of the affected municipalities. Past experience in Ontario suggests that this manner and form requirement could likely be circumvented by the province by, for instance, amending the legislation to include an exception to the rule or remove it entirely. However, it could be made enforceable by including a clear procedural rule to override the requirement for a referendum, for instance, through a 2/3 majority vote in the provincial legislature. In some, municipal systems ought to be seen as part of provincial constitutions, and therefore reform to municipal systems ought to be approached with care. We need more thinking about how to limit provincial authority in municipal affairs while also balancing the need to take metropolitan areas and the province as a whole into account, as Zach Taylor discussed in his presentation yesterday. And I think that my proposal here actually fits quite nicely with what he is suggesting, but I'm emphasizing the need to also provide constitutional recognition and protection for municipalities. And I propose that manner and form limitations could provide one such option. Provinces should enact such limitations in municipal legislation through an incremental process that makes sense for the particular area of authority or governance. And provincial elites should stop invoking the notion that municipalities are creatures of the province as though it is the end of the legal or constitutional story. It's very damaging to democracy in Canada. Thank you for your attention, and I look forward to your questions and comments.
Thank you. Thank you, Kristin. To our next speaker now, Professor Valverde.
Okay, start my video. All right. Okay, so hello, everybody. So I agree with a lot of what Kristin just said. I mean, some of the details, we could talk about, but I certainly agree with the sentiment, and that same sentiment about needing to change the political structure of Canada was voiced in all the panels that I was able to attend yesterday. And I do have a paper that sort of goes through the legal history of municipal corporations in Canada and has some stuff on the history of social democracy, of local democracy. I mean, you can read that in the Osgood Journal of Law and Social Policy, which is open access. So if you're interested in a more scholarly paper, you can read that. But I thought I would take the opportunity today to do something I think we can do in a few minutes, which is to do a bit of blue sky thinking. Now, it seems to me that the pandemic has brought into question what is and is not radical. And so a year ago, it was completely radical if you knew anything about city politics in Toronto. It was completely radical to think that you could create a lot of long bicycle lanes within a couple of months. Any city official or any city councilor would say, oh, that's impossible. It has to take at least 5 years or something. Well, guess what? It happened. So, and I think a lot of other things have happened that we thought couldn't happen. And the capacity of different states, local, provincial, and federal, to move quickly and to do things like, put in CERB and have people getting $2,000 a month within a few days, that would have been thought of as too radical, too impossible, whatever. So I think the pandemic, I mean, now that we're approaching the end of the pandemic, it's a really good time to say, okay, let's have a really good look at our political infrastructure, because it's as much in need of renovation as our physical infrastructure. And so this is a time when I think we can move with a more radical, quote unquote, approach. And of course, when people hear anything about the constitutional status of cities, they say, oh, we couldn't possibly have another constitutional conference. Nobody wants that. Well, I don't want that. If it's going to be 10 premiers or maybe 12 premiers, if you're lucky, and the federal government meeting behind closed doors, I mean, who would want that? I don't want that. But there are alternatives. And if we look at other countries, we can see that the Constitution can and maybe should be changed, but through a very different process that is not contemplated in the 1982 Constitution and its amending formula. So what you can have is a constitutional assembly. They did this in Chile a few months ago, even though the government there is fairly right-wing and not necessarily keen on a new constitution, but they had a constitutional assembly. A constitutional assembly is made up primarily of civil society groups. And in Canada, we would of course have First Nations and other Indigenous peoples, not only represented, but in my view, running the show, moderating the discussion. I think they would do a better job with their approach to meetings than we have done with Robert's rules. So I think we need to think about a constitutional assembly that would be a bottom-up kind of gathering with First Nations and other indigenous people sort of at the forefront, women's groups, tenant groups, racialized groups, and so on. And where politicians and also lawyers kind of took a back seat. And the lawyers, I think, would be useful to then turn the decisions of that assembly into law. But they would only sort of come in at that end instead of leading the fray. So anyway, I just wanted to bring out that supposedly radical idea of a bottom-up constitutional assembly to really look at the question of the Constitution, because as it is now, you can't really do anything that a significant number of premiers is going to dislike. Well, why should they be the, dictators of the country just because we have an amending formula that is what it is? So a constitutional assembly is an idea that I'd like to put forward and see what you all think about it. So thank you.
Thank you so much, Professor. Really interesting ideas coming to the fore. Our next speaker is Professor Patricia Wood. Professor, my papers are all flying over. Patricia Wood, Professor, Graduate Program Director, Geography, York University, also joining us from Toronto. Patricia, over to you.
Thanks very much. Good morning, everyone. What I'm going to do is present a quick scan of the historical geography of how the Constitution has shaped the city and how the city has shaped constitutionalism in Canada. In my thinking about municipal governance, I center geography, by which I mean I center cities as physical places and the actual practices of inhabiting the city. I also approach the Constitution and constitutionalism as living or lived practices that are also of and about a place. Place is always an inextricable fusion of a material location and ideas about the meaning of that location. The tangible and the imagined are not the same thing, but they're always both part of place. And so constitutionalism and cities overlap in the ways in which the city is a space that produces and is produced by political subjects or citizens. So I'm approaching governance not merely as a set of structures or institutions, but as a relationship to place. Governance also includes all the processes through which we determine the ways in which we will live in and reproduce this place, whether that place is a neighborhood or the city of Toronto, the province of Ontario, or Canada, because in producing and reproducing any one of these, we also participate in the production of the others. I am particularly interested here, obviously, in the production of political place, which is another way, I think, of speaking of constitutionalism, the processes by which we determine the principles by which we will live and constitute ourselves as a polity. As I apply all of this to the status quo of the Canadian city and the question of whether or not it has the powers it needs, the purpose of this historical geographical scan is to emphasize the intentionality of this status quo. There are many aspects of the city that are accidental. It is a place of random encounter, which generates creative and improvisational activities that are unplanned, unpredictable, and even ungovernable. Nevertheless, it is overwhelmingly the case that the situation we have today is what the actions of politicians and policymakers and political elites have driven us directly towards. I've been teaching geography for more than 20 years, but I was trained as a historian. So I always start with, to understand where we are, we must understand how we got here. So let's start with the point that cities are inherently political spaces. Cities are sites of political administration. They are a site in which the state takes up literal space, and they are thus occupied, both spatially and culturally, with formal political institutions. Cities are also sites for more informal political actions from civil society. They are a site for citizens to speak to the state in formal and informal ways. And this arises from a multiplicity of factors that accommodate the necessary visibility, accessibility, and collectivity for such political speech, such as the quality of the public sphere and media coverage. This understanding of the city in Canada goes back to the earliest days of settler colonial settlement, and it's part of the relationship between settler governments and Indigenous peoples. For example, in the summer and fall of 1880, hundreds of members from several individual First Nations protested and occupied in Calgary, Battleford twice, Prince Albert, Edmonton also twice, and Duck Lake. They all did so for different reasons, but they all came to the city to engage the state to make claims, and in all of these cases, many of them in fact were successful. As Giuseppe Dusso has written, only by thinking of citizens as being governed is one able to understand resistance in a constitutional way, or perhaps as something that resembles the right to resistance. Resistance needs to be recognized as a component of constitutionalism because it acts to change the principles we live by, which thus constitute the people as a polity living together non-coercively, which is how we tend to think about democracies. Resistance includes formal, institutional forms of politics, as well as civil society, whether organized or informal, or even spontaneous. All resistance should be understood as an effort to alter the cultural and legal self-understanding of political communities. Acts of resistance challenge the principles that constitute the polity in practice. They dispute the sincerity of formal constitutions and the equalizing promise of citizenship as an institution and as an identity. They accuse the state of violating its own principles, of oppressing violently its own citizens. They thus raise questions about the meaning and practice of democracy and the capacity of the state to deliver on its promises of governing. They demand the state be accountable, and they constitute themselves as citizens who are entitled to make such a claim. In addition to the city as that political site and stage, the city and citizenship as an institution can be coercive and disciplinary, particularly as a space of observational and administrative surveillance. The politics and policing of everyday life in the city has also been significantly enhanced and extended by such things as video and smartphone technology. But whether it's contemporary or historical, this policing has been applied unevenly, geographically and demographically, and has been used for social and political purposes as much or more so than legal. At the same time, the city is equally political in its capacity for diversity, anonymity, innovation, and freedom from tradition, which has made the city historically a profoundly empowering and emancipatory space. For example, women, Blacks, and queer communities have all sought and found freedoms in the public space of the city that were and are unavailable to them in rural areas or in the private space of the home. The social geographies of cities that give rise to much of the material and social deprivation that in turn gives rise to resistance are not accidental. One of the formal constitutional roles of the city was to establish state dominance over land and colonized peoples by settlers and their governments. Municipal governments have been active in these processes. From the Maliseet in New Brunswick to the many other First Nations I mentioned earlier in Western Canada, Indigenous peoples were excluded intentionally from city spaces. And city charters were one of the tools through which exclusions of any community unwanted by elites were enforced. The oldest city charter in Canada is claimed by St. John, New Brunswick in 1785. It used the municipal charter explicitly to identify free citizens as only the American and European white inhabitants, and thus it forbade Black British loyalists from practicing a trade, selling any goods, fishing in the harbor, or voting. Similarly, unmarried women's presence in cities has historically been monitored by morality police squads, and their political voice was thwarted by laws that denied them the right to participate or to hold office. cities have been planned and policed intentionally as racist, sexist, ableist, homophobic, and transphobic. Cities have been seen as sites for establishing norms of what it is to be a good citizen, and these norms have been built into their spatial orders, legally and socially. The second constitutional role of the city was to establish local administration and actively fend off local democracy in British North America. The second oldest municipal corporation in the world, after London in the UK, is Chennai, India. That corporation was established in 1688 by the British King James II in the midst of the Anglo-Mughal War, which reduced British claims to Chennai and what is now Mumbai. The first Indian mayor of Chennai was elected in 1919, and that should give you a quick idea of how much that municipal corporation was concerned with local democracy. A similar antipathy for and suppression of local democracy in Canada has very deep roots. In the early days of British colonies in Canada, governors banned town meetings out of a fear that things might lead to, quote, wild democracy and even revolution. It was believed, correctly, that New England town councils had been a key factor in the American Revolution. As Engen Eisen has written, cities in British North American history originated as cities without citizens. From the beginning, cities were never allowed to develop practices of citizenship. Municipal government institutions in Ontario and other provinces were thus built as administrative instruments of the province. Their powers have always been carefully curtailed. Canada never threw out its British governors, and it has never amended its constitution, as we have all been noting, to include municipal powers and authorities, as India did in 1993. The formal and informal constitutional roles of the city clearly overlap, but more significantly, they are a bit at odds in that cities are both empowered and empowering, and disempowered and disempowering all at the same time. And they return us, I think, to the importance of resistance as a constitutional force. Canadian cities intentionally empower certain citizens and deny citizenship in practice to other residents. British colonial cities were established to quell resistance, but their deep inequality fueled that resistance, and this pattern continues. So what then does constitutional change for cities mean, or what should it mean? I believe that advocates for more constitutional powers for cities must be honest about what they want those powers for. I have spoken before of my worry that the city charter movement is one of largely privileged voices, that it is largely well-to-do white residents who prioritize the idea of new powers for the city because it possibly solves the only real governance problem they have. But so much of the rest of the city struggles to have its issues heard and addressed. The vulnerability in this city, as well as others, is extraordinary, but that suffering is not commonly the city's priority, even in these pandemic times. In Toronto, racial polarization and its consequent material deprivation is growing. One more point. As we consider the most just approach to municipal governance, we also need to ask what is the role of the region. In political geography, a region by definition is not a jurisdiction. It's a term we use for areas that fall between political jurisdictions. So we can have regions within the province, regions within countries, we even talk about world regions. The word is for the in-between space, right? The one without formal political jurisdiction and often formal political representation. So what we know about governance in regions is that regions are particular governance strategies. One of the elements of regions that makes them so strategically attractive is the way we can imagine them as unformed empty spaces because they don't exist until we imagine them. But regions, of course, are not singular identities. They are complex, multi-scalar entities, and they are constellations of many places. And those places in the constellation are not the same and they're not equal. And in the greater Toronto and Hamilton area, there are strong differences in these individual places in income and well-being and in access to opportunity. At the same time, it is important not to fall into what Mark Purcell has called the local trap, where we fetishize the local as an inherently superior form of governance. Local governance can also take the form of NIMBYism. Like any other scale of governance, Local governance is not immune to racism or open class warfare. And so local governance is not a certain path to good governance or social justice. We should not equate the local with the good, especially given the empirical fact, as Purcell has noted, that local scale arrangements do not always result in a more democratic or more just outcomes. And as Warren Magnuson has also argued, we should be skeptical about a political logic that suggests that the only solution to a problem is to repose the problem on a different scale. The right to the city is not to privilege the urban as a scale, but rather to emphasize that the rights of inhabitants should not be diminished or extinguished in favor of owners or other elites. Progressive urbanists often feel threatened by regional planning, and in many instances for very good reason. Nevertheless, this question of the region matters in the consideration of municipal powers because the regional has historically been an important progressive counterpoint to self-interested NIMBY localism. And importantly for this question, the province and the region are not the same thing. And the failure of the provincial government and others to properly distinguish these in structure and in discourse is a further obstacle to having clear discussions about the role of regional governance in municipal governance. Approaching governance not as a set of structures or institutions, but as a relationship to place, I think raises fundamental constitutional questions. How should we live here? What are our obligations to each other? And what are our obligations to this place, to the land? Historically, Canada has answered these questions by producing cities as places of administration and surveillance, and as places of violent social exclusion. Citizens have resisted these ideas and shaped cities into places of emancipation and inclusion. Those advocating for constitutional reform of cities should be mindful of what has been the actual source of progressive change and cautious of the conservative and exclusionary tendencies of local democracy, including at times even the use of city charters. Meaningful and just constitutional change for cities would include some form of statutory expression of the principles we aspire to, as well as the expansion and protection of spaces for civil society and for the resistance we need to hold us to our commitments. Thank you.
Thank you so much, colleagues, for those really pithy but forceful presentations. And we've heard some interesting and I would say some challenging ideas. You know, Kristin with a focus on provincial constitutions and manner and form limitations. Mariana with the radical idea, time for radicalism is now. If now, then if not now, then when? She poses, and her proposal of a constitutional assembly. And Patricia with a mindful reminder that those of us who love cities should put a check on our ambitions, because cities are the source of much exclusion as well. So we're going to proceed with getting questions from the floor, but let me try and kick this off with a first question to Kristin, who focused on constitutional on provincial constitutions. Now, I'm a senator. I work in Ottawa. I now look at things a lot through federal eyes, a lot more than I used to, and I have noticed some interesting, openings. And I'll give you an example. In the past 3 or 4 years, the federal government has had direct dealings with municipalities, as in the case of providing funding for asylum seekers in Toronto, and the province refused to play ball, or in the carbon pricing platform, where redistribution to local schools and hospitals will happen through federal means, and the new proposal, which is really in its beginning stages, to allow municipal governments to nominate immigrants to their places for settlement. So, Kristin, do you see these, sort of as points of light to build on, to enhance the conversation between the federal government and local municipalities, or is this just flash in the pan expressions of momentary exasperation?
Well, I guess first I would say, oh, am I unmuted? No, I am
Yes.
unmuted. First, I would say that, in terms of abandoning this notion of creatures of the provinces, I think that it's also been a barrier to establishing that relationship between municipalities and the federal government. And I think what we're seeing now, and I'm kind of, influenced by people like Neil Bradford by, describing it this way, but I think what we're seeing now is the emergence of an implicit, or during the Trudeau years, sort of an implicit urban policy that's growing and likely will have to grow post-pandemic. But this kind of implicit policy, rather than a strongly institutionalized policy stance, is vulnerable to, the will of the government of the day, right? So this could change. But I have seen some consistency in the immigration field. You raised a couple of examples there in terms of local immigration policy making, and this has been happening even before the municipal nominee program. There was the local immigration partnership that was established by the federal government, which is basically funding for intersectoral partnerships, at the local level. And often they're housed in municipalities. And this actually builds on what has been an area of municipal innovation, I would say, in Canada, in terms of, especially in the largest cities, the core cities like City of Toronto, City of Vancouver. My first book was on sort of the rise of municipalities in the immigration policy field, and municipalities have been highly innovative in this area. And I think it's an example of that kind of shows that there is a progressive potential at the municipal level. But yes, I think those are interesting initiatives, but I'm just not sure how long they'll last. It just depends on the government, unless we do see further institutionalization of that federal role in urban affairs. And there are barriers in Canada to that. One being that we're in a multinational federation, and any centralization of power or perceived centralization of power would be resisted by Quebec in particular, and some other provinces as well. So I think there are a lot of barriers to that. But I don't think that the idea of empowering municipalities within provincial constitutions is necessarily opposed to that. I think that we should both empower municipal governments within provincial constitutions and find ways to integrate them into the intergovernmental system as well. Their work needs to be done there as well.
Okay, great. Mariana, I was taken by your idea of a constitutional assembly, ground up, bottom up, not up down. But again, as a politician, I think of attending one of these, and I think of some chaos that could happen. What about what rules of governance should surround such a constitutional assembly so that they don't descend into a disorganized conversation without an objective and an end?
I don't know, because I just had the idea of the Constitutional Assembly yesterday when I was listening to the panel of mayors that was chaired by David Miller. And all three mayors on that panel were from smaller towns. And I thought, well, they're totally left out of the city charter kind of stuff, but they're doing really interesting things. And I thought, those people, the mayors of smaller cities in Canada, those should be given a seat at the table at the Constitutional Assembly, but not MPs and not MPPs. And I'm sure there's political scientists who've studied how constitutional assemblies have worked. I mean, in Colombia, they had a new constitution, brand new constitution in 1991 that I know something about, that has much more by way of inherent rights, not just for Indigenous people, but all sorts of other, marginal groups than other constitutions. France has been through 5 or 6 constitutions since 1791. if other countries have done it, presumably one could go and study best practices and how not to, have it be total chaos. And perhaps having virtual meetings would be good so that people aren't obligated to all somehow pay for their travel to, Ottawa or wherever. And I think it shouldn't be held in Ottawa. So I'm sure that there's experiences out there. A lot of other countries have written new constitutions. And I mean, I appreciate the work that Kristin and, a good number of law professors that I know have done by way of suggesting clever ways in which you could sort of get around the notwithstanding clause or something like that. I sympathize with that, but I think this is a time, like as you just said, if not now, when? So if now, there's all sorts of people in Canada who didn't seem to know that gender discrimination is not going to go away all by itself just as time goes on. And suddenly they say, oh, gee, gender discrimination in the economy is not going to go away unless the state finances childcare, things like that. So a lot of people have realized, and certainly with settler colonialism, a lot of Canadians have really started to rethink their basic narrative about what this country is and who they are as people. So why not put out this idea? And maybe it won't ever happen, but why shouldn't we consider it? Why should we be stuck? I mean, the 1982 Constitution is no more democratic than the 1867 Constitution. It has a Charter of Rights, which empowers individuals as against the state, but it doesn't do anything to empower marginal groups. Mm-hmm. And in terms of Indigenous rights, the 1982 Constitution was pretty bad, except that the Supreme Court has creatively read things to, which hopefully they'd be willing to do for cities as well. But all I'm saying is that it should be an idea that is at least discussed, because if we just sit around thinking about how to fiddle with some obscure section of the Constitution that allows a constitutional amendment for only one province, well, okay, fine, but let's think a little more broadly.
Okay. Thank you. And my last question is my last question, there are questions piling up and we'll get to them, so I'll make it brief, is Mariana to you, Patricia, to you as a scholar of geography and history. The narrative and the context of today is to a large extent grounded in the search for racial justice. And cities, we know, are attractive like a honeypot for minorities for many, many reasons. And Jane Jacobs famously said that the level of government furthest from the people is best positioned to protect its rights. But the level of government closest to the people, which is municipalities, is best positioned to deliver services to it. Do you think this still holds good in the context of racial justice and the conversation we're having today about cities?
I think broadly speaking, it does, probably more the first part than the second. I mean, it has always been the case, the frustrating case, I think, for democratic thought and practice, that it often takes non-democratic or the least democratic bodies most removed from a situation to, uphold constitutional promises of equality. It is often, with reference to what Mariana was just talking about, it is often courts enforcing the Constitution that was, generated by democratic bodies that leads to, equitable treatment and the real real citizenship in practice. I'm not 100% persuaded that the local is always the best for the provision of services. I think that, again, depends on how that is rolled out. I think it is. I think there are some services in which that just logistically makes the most sense, but it doesn't necessarily make it the most equitable. Cities, have responsibility for certain services already, and I can easily, anyone could point to Canadian and American cities, off the top of my head about their inequitable delivery of those services. We could point to that with COVID vaccination rates, for example, right now. So the city is in charge of that. It is not being distributed, appropriately or equitably. I do think, though, there is a possibility for changing that for something like the vaccination program, for example, that needs a kind of immediate response. There is a flexibility and accessibility to politics that at the local level that makes it the most well-suited. It does not by any stretch a guarantee. I mean, it's important to remember, like, that kind of double-edged sword of the cities, that for all the reasons that it draws in people and is genuinely emancipatory, it is always at the same time, historically been this active force of exclusion and inequality. And so that always needs to be recognized and resisted.
Thank you, Patricia. There are no saints then, in other words, in this room. We're going to go over to the floor for questions. Please keep your questions coming. The first question is from Rhonda Quiner. I hope I'm pronouncing your name right. Would we need a change to our federal constitution's amending formula in Canada for what is being discussed to happen? I think Rhonda's question is to Kristin around provincial constitutions. I think that's what it's about. Kristin, over to you.
I'm trying to unmute, but it's not working.
You're working now?
Oh,
I can hear you.
Okay, great. No, I mean, provinces have the ability to amend their own constitutions in the larger context of the Constitution Act 1982. That's listed under Section 5 of that Constitution Act that was passed when the Constitution was patriated. And before that, it was actually in Section 92, the first section under Section 92, where you see municipal institutions in Section 8. It was number 1 that was actually the amending formula, which kind of drives home the point that we can look at Section 92 actually through a constitutional lens, and that provinces were given the power to not only legislate in particular areas, but also to establish themselves as democracies and establish a constitution for themselves. So the answer is no, but the challenge that I've been grappling with ever since I became interested in cities is really within a flexible constitution that is kind of in the British mold of responsible government and a single parliament without an entrenched provincial constitution. How do you actually protect municipalities within that system? If, does it really even matter if we consider municipalities constitutional? I think it matters just to recognize that, because I think that would change how the public sees it and would change things politically. But ultimately, if provinces can change their constitutions and it's by majority vote, it's really no different than changing an ordinary law. So that's why the manner and form mechanism becomes important, because it's a way of protecting certain laws that are deemed constitutional that has developed, in Commonwealth countries that are grappling with this issue, like the UK, for instance. How do we protect human rights legislation? How do we protect devolution and people like John Stanton, who discuss some of these issues through a municipal lens, actually talk about municipal government as being part of the Constitution. So anyway, I think what occurred to me is I had a colleague, David Cameron, who I replaced at Dalhousie in 2005, and he wrote an article in 1980 arguing that municipalities should be seen as part of provincial constitutions. And it kind of, as I spent time at Dalhousie, there's a really rich tradition of constitutional law and history and like institutional type studies at Dal. And I realized that he wrote that article because he looked at the Constitution through a British lens. And I think I'd been more influenced by American ideas of constitutionalism. And so he didn't think, well, it's municipalities aren't part of the Constitution simply because we don't have a written consolidated document stating that. It was a more open-ended question for him. So anyway, I hope that's a bit of a a long answer to your question, but I hope that covers what you wanted to know about.
Well, here's another question coming to you, Kristin. This is from Natalie de Rosier. How do you think manner-informed legislation would have prevented the Ford government from changing the rules during the municipal city election? And I think we're all familiar with what happened there. The City of Toronto Act already provided for a requirement of consultation, which the provincial government simply amended. A 2/3 majority may have been achieved as well. I'm not quite sure what the last clause.
I think it all depends on the balance of power in terms of parties in the legislature, right? In terms of like how the manner-informed mechanism would work. And I guess, you'd have to get creative and look at, well, what kind of majority would be needed to ensure that there's at least some cross-party support. And there's no magic to that rule. I mean, it could be anything, right? It's completely flexible. As long as it's not so rigid that it couldn't actually, the law actually couldn't be changed. At least the late Peter Hogg thought that it would be enforced by the court. But in the particular case of Toronto, there's a commitment to consultation that's in the legislation, but the City of Toronto Act, but it's vague and it's not stated as a procedural requirement. So I would say it's not a true manner-informed mechanism. And also if manner-informed, and I mean, with consultation, it's a fairly light, requirement to begin with, but at least it would slow the process down politically. Everything happened very quickly. And I think, Parliament and, our democratic debate is, around an important issue like municipal reform. We need time to discuss it. We need, different voices, articulating their positions on the issue, and that takes time. So it brings more political attention and slows down the process at the very least. I'm not sure what the precise balance of power is in the Parliament right now in terms of 2/3 or what the number would be, but that could be, it could be anything, the requirement. So, and I just want to make a more general point that one of the appeals of looking at municipal autonomy through a provincial constitutional lens is just that if you look at their place in the overall system and within the context of provinces were never meant to be, the Constitution has evolved over many years and become much more democratic, right? And, Patricia has drawn our attention to some of, what was the actual, rationale behind establishing municipal systems initially was. But things have changed through time, and provinces were never designed in the original Constitution to be powerful. There were competing conceptions of the Constitution, but we had a quasi-federal system. I mean, the federal government could reserve and disallow provincial legislation. So, and that's just one example of the centralization of power in the original Constitution. So we didn't design our Constitution to actually have the provinces that we have today. And that happened through court interpretation, political movements, the fact that we are a deeply federal society, like for a lot of different reasons. And the other thing that changed was that political parties became very, very disciplined. And, now legislatures and even cabinets are being bypassed by the political executive. And, the idea that a municipal system could be reformed based on a premier's decision, he or she doesn't even have to consult their ministers anymore. They might just do a few polls and, talk to the premier's office and then implement this kind of system that is so change that is so fundamental. So anyway, that's also another long answer, but I hope I covered what was necessary there.
Thank you. I don't know who the next question comes from, but I'm going to throw it open to anyone who'd like to weigh in. I think Patricia, as a historian and scholar of history and geography, possibly, and it's about Ontario and specifically about some of the decisions made by our provincial government that dampened local governments' ability to make its own decision. The famous one, of course, Premier Ford cutting the size of city council in the middle of an election, unheard of. And secondly, more recently in 2020, his decision, and I think it came from the executive office, you know, you could well be right on that, bypassing the party system. And the second decision around eliminating London's decision on ranked ballots. So the question is, what is it about recent politics in Ontario that makes this kind of thing more common in this province than in others?
I can start to answer that.
Okay.
I think I would start to answer it by saying I'm not sure it is more common in Ontario. I mean, there's something extreme about what happened, as you've just described, in terms of the you know, the timing and the speed of the decision. But Ontario is not the first province to empower and then disempower and then empower its cities again. Albertans are very familiar with this in the last 10 years or so, as well, as it's gone back and forth. They had actually, under one government, moved, and the previous government moved towards a new kind of city charter system that included, very importantly, a revenue sharing model, and then that disappeared before it was implemented with the arrival of a new government. So the back and forthing of it, not unique to Ontario. One of the things I think is going on in Ontario is the battle, I guess, between the city and the province is in some ways a battle among elites that we see played out in a lot of others. You know, part of it is aligned with partisan politics and part of it is not. But I always point out that Doug Ford himself is from Toronto. So in some ways, this battle between you know, what appears to be a battle between the city and the province is an internal battle that is about you know, Toronto elites arguing with each other about who's going to make the decisions. One of the concerns that I often raise, as I tried to hint at today, is you know, I'm not yet persuaded that there's something inherent about you know, which side of that wins. I mean, if we had gone, that is inherently better. If we went back 5 or 10 years and we have Kathleen win as premier and Rob Ford as mayor, do we still want the arrangement that we're looking for now? You know what I mean? Like it's more complicated than a scale thing, and it is absolutely a very serious question about city powers and about cities being recognized as orders of government whose elections are just as valid as any others, and so that every voter and candidate has the same rights as they should, as they would in a provincial or federal election. That is still a very serious issue, but how this is actually playing out is not necessarily only about that issue.
Okay, so I'm going to move on to other questions. I want to give every question a fair chance. So I know all of you will have had something to say about Ontario, but we're going to move on. There is a question about provinces in general. It's a provocative question, but one that I've often heard in these gatherings. Do we need provinces anymore? Should we simply not have national standards implemented by municipalities? Okay, let's go around the table. Quick answer, Patricia, Mariana, and Kristin.
Very quickly, I'm thinking of Kristin's comments. The very first thing I think I heard in my constitutional history class on Canadian American constitutionalism was the irony that Canada sought to have a highly centralized federal system and has a very decentralized one. The United States sought to have a decentralized one and wound up with a very centralized one. The reality is we have a very decentralized federal system in practice. I cannot imagine the dysfunction trying to eliminate like never mind the process of eliminating the provinces, but then removing them. And I think it's also important to note, again, historically, that all provinces are not the same as polities. There are some that really are, you know, reflections of communities that came together, and there are some that were imposed by lines on a map. The provinces do not understand themselves, the same way. So it's a very, very complicated question. But no, I can't imagine Canada without provinces.
Yeah, as we are debating long-term care and national standards, there are moments when I wish there were no provinces, because, in that context, it would work much better. But let me get Mariana into this conversation. Do you think provinces should simply be, what was the question? What was the word used? Abolished. Do we need provinces anymore? I think we've lost Professor Valverde. Okay, well then let's just carry on. Patricia, do you want to no, Patricia, I've already. Kristin, do you want to weigh in on this question?
Sure. I think provinces, I think we're a deeply federal society, so I think it makes sense to have provinces in place, and it made sense at the time. The Constitution was designed. Some people might be better off if we didn't have provinces in terms of redistribution of wealth. It's a major barrier to redistributing wealth, because it's always becomes about the politics of, territory. And it's also, federalism is also a barrier to, the establishment of a, national, like, class-based politics. And it's, our political parties are more, brokerage parties and pragmatic because of federalism. But on the other hand, I do think we have a deeply federal society, and even if differences weren't as great in the past, but I think with a vast territory like Canada, we needed a federal system, and with Quebec, of course, we definitely need a federal system. But yeah, there are costs and benefits to the system, but we certainly couldn't turn back now either. I think that regardless of the identities at the time of Confederation, that once you establish the political institutions, the political identities grow up around them, and people are very much attached to their provincial identities as well.
Thank you. There are lots of questions. I'm not sure we'll get to all of them, but let me try. And this is for you, Patricia. You have raised important questions about how a local lens has historically been used in an exclusionary way and not in an inclusionary way. How do we ensure that there is a balance between the power of the local and protecting the wider idea of civic commons and public good?
I would point to Professor Valverde's suggestion as one possible example. I think if we always rely on existing formal structures and pretend that they haven't, emerged from the, active processes of elitism, then we reproduce the problem. I think we have to think outside of that, especially if you're talking about formal processes of inclusion. And I think Professor Valverde's suggestion is one that has been used in other places and can be made explicitly more inclusive and more representative. I also think the more that municipal governments work with civil society and community organizations and attend to the very sort of specific practice of inhabitants, in a very local material way, the more their work is just necessarily informed. And that can include, just as an example, a very serious and principled reform of public consultation processes.
I'm remembering the public consultation processes around electoral reform in this province and in others. And I'm still concerned about the lack of let's say, appropriate governance mechanisms, but it's certainly an idea whose time has come, and maybe we should just test it out and do it. So there's a question around, and I think it's again to both of you, and I'm really sorry we've lost Professor Valverde. Some of these questions would have been right up her alley. How have past an ongoing devolution of responsibilities from the federal provincial level, for example, on housing, immigration, transportation, public health, how have these affected the role and potential of municipalities to be more independent, or the opposite? Kristin, you want to take this one on?
Sure. Well, it's kind of interesting because my initial interest in cities developed at the University of Toronto, and it was making the move from Winnipeg, where I grew up, to the city of Toronto, and just seeing sort of the level of activism at the city level there, and becoming interested in the city of Toronto's role in access and equity, immigration policy, and just the kinds of issues that were being discussed at the municipal level there, and then kind of almost the lack of attention to municipal governments in the political science literature that I was noticing as a PhD student back in 2000. It really drove home to me that, you know, the two are connected, immigration and like the changing role of cities in Canada, and I saw them as connected, and as it's sort of evidence of the potential, I think, of municipal governments in the country, their emerging role in immigration policy, and the fact that ultimately municipal governments need to be able to step in to meet the needs of residents, because upper levels of government cannot be trusted necessarily to deal with issues on the ground. And they don't have the same sense of urgency because they're not hearing directly from their constituents. There's a pragmatism and progressiveness that comes from that engagement with civil society as well that Tricia spoke to. I think that you know, the governance element, the fact that their municipalities are positioned to engage with civil society, I think that's an advantage that can be channeled into a more progressive and responsive government. So the two were linked.
Okay. Thank you. We have a question from India. It's kind of interesting. I didn't know that this conference was attended by people from so far away. And this is a question from New Delhi, my hometown. So I'm going to privilege it a little. And I'm going to give this question to Patricia because you did reference local authorities in India, in Chennai and Mumbai. And I'm not actually sure I understand this question, so I hope you can. It's just because of the reference that may be particular to India. How does protest and riots as an act of resistance, as we saw in the anti-CAA protests in India, affect the form of cities and its relationship with the Constitution? Does it need a greater constitutional representation? I'm thinking the CAA protests may well be the protests around the change. I'll leave it up to you, Patricia, to figure this out.
Okay, I was gonna say I can't speak to the specifics of that protest. I can say that riots have been remarkably. I don't want to focus on you know, more intense activist forms of protest, but I would note that riots have been remarkably successful at bringing about you know, meaningful change when other forms of, you know, more allegedly civil forms of engagement have failed. And they are often about, you know, the actual material space of cities. So, you know, rights to housing, rights to actual, you know, use of public space, and so on. So I think that's kind of part of the question. And so that's what I'm sort of trying to get at the end of my comments, that any envisioned kind of constitutional reform or charter building should include a set of principles and practices that actually really understands the value of the public sphere of the city, because you need a healthy public sphere that's very accessible, that's not over policed, for example, that enables people to really participate in these practices, to recognize that even informal social gathering is in its own way, you know, constitutive of a healthy democracy, to enable people to participate. It doesn't have to come to riots, but I've never been able to condemn riots as a political act because they have been so remarkably successful in breaking through, especially you know, racist legislation, for example, like to break those kind of structures down.
So a conference attendee has put an interesting note in the chat that Brazil and Barbados are both rewriting their constitutions, and it should be interesting to see the results, and that should be interesting. The next question comes from some of these questions have to some extent already been answered by you. Yep, I think that one has been answered. People are asking, is there a Canada without provinces? I think we could talk about that for a long time, but I'm going to move on to a question around right loading, and I'm not quite sure who it comes from. Aren't there functions municipalities are better at planning, delivering, and being held accountable for, and right resourcing for that, and offloading some of the responsibilities that they may not be, let's say, particularly well placed to deliver? Do you have any ideas on that? Right loading and right sizing and right resourcing, Kristin and Patricia?
I'm not really sure I understand the question. To me, in part, it sounds like the questions around scale, where scale is seen as the problem, and so scale is the solution. That's rarely the case. But I do think there is something to the difference between, lived encounter and virtual kind of connection. So, that kind of lived experience, practiced experience of local democracy. So, and there are theories, Jane Jacobs had some around actually, kind of what are ideal sizes, even for taking a larger thing like a city and breaking it down into components, wards, and so on. I think there is some value to that kind of discussion and that kind of thinking. I'm going to wrap it up there because I noticed that there's a comment in the chat that we're supposed to wrap up.
Yeah.
Oh, okay, but there's a final interesting question around trilateral agreements. There has been a history of trilateral arrangements on certain files. Why not build on these? For example, a new childcare system, where municipalities are the level of government that delivers the services. I think. Okay. Kristin?
I think that's a way of coordinating tri-level action and thinking about how to carve up different policy areas in ways that make sense for each level of government, and trying to have some really broad country level standards, some specific onto provincial level standards, and then leaving municipalities to do what they're best suited to do. It's interesting that this municipal nominee program that you brought up at the beginning, it's often something that a lot of people on the ground would argue is not the right thing for municipalities to be doing, because immigrants can move to where they want to after. So are we done now?
We are done now. I'm being told very clearly.
1:15 that we
Thank you so much, colleagues. Wonderful conversation. We could have it forever, but for now we are adjourned.
Okay, thank you.
Thanks very much.